My dear friends, welcome. Good morning, all of you. Now we are with you a new topic, new session, and a new energy of the knowledge. That is BPSC 131. And this is the new topic that is family, law, and state. This is political theories concept that family, law, and state. My dear students, it will be a great pleasure for you that we have started again this topic, and this topic concern with the law and the state and the family. So you will learn many and many topics with this regard, and we will start with this now. Okay, so please be with us with a good brain. This is now family, law, and state. As usual, if we say that what is family, what is law, and what is state, this is depend on that in which concern we are discussing now. We are concerning these all topics regarding with the sociological aspect, regarding with the political aspect, and regarding with the economical aspect also. So family is regarding in regards with all of the concepts, and law is also considered in all of the aspects, and the state always cover and considered in all of the aspects of our society and of our behavior and our livelihood and our everything depend on state. So this is all and this all of the political ideological concept covers the family law and state. So we are starting now that first of all we have to understand what is a state. This is here that state what roles has to be declared by the constitution and by the society. So defining the term state is not easy as there is no general agreement on it definition. As we say that state is word is not so easy that is there is no any agreement has been done according to dignified otherwise we can say identify the state definition. It must first be noted that there are various forms of the state which differ from one another in important ways. The Greek city state is clearly different from the modern nation state, which has dominated world politics since the French Revolution. If we, now we are going to start with what state has remained and what is the state is now has the value. So this, if we say that Greek city state is clearly different from the modern nation, and that has to be clear that the Greek city state has dominated world politics until the French Revolution. State has more and more powerful domination and more, we can say, powerful aspect related to the politics. And after the French Revolution, there has the Greek city state has changed their scenario, and French Revolution has given some changes. The contemporary liberal democratic state, we are saying about here that contemporary liberal democratic state which exists in Britain and Western Europe is different from the fascist type state of Hitler or Mussolini. It is also different from the state which existed in the former USSE and Eastern Europe. An important part of the study of politics and certainly an integral element of this book is the explanation of what is meant by these terms. Now here that as according green Greek city state, there is we have given this Greek city state as now here contemporary liberal democratic state. What is difference is here that which exists in Britain and Western Europe. This the existence of these contemporary liberal democratic state exists in Britain and Western Europe is different from the fascist type state of Hitler or Mussolini. It is also different from the state which existed in the former USSE and in Eastern Europe. If we say the contemporary liberal democratic state is just like it only exists in Britain and Western Europe. And this is also have a difference from the Hitler and Mussolini state type, and this is also different, has a difference in former USSCE and Eastern Europe. An important part of the study of the politics, and certainly an integral element of this book, is the explanation of what is meant by these terms. There are different forms of the state, but whatever form one has in mind, the state is as the same as the government. It is rather complex of various elements of which the government is only one. In a Western type liberal democratic state, now we are saying here that in a Western type liberal democratic state, what is there? Because we have given the difference between many states, as we have given the statement about the contemporary liberal democratic state. Before that, we have given the Greek city state, the Greek city state, the contemporary liberal democratic state, and now here there is also a liberal democratic state, has also the government, has also the form of the government, are indeed with the state power. They speak in the name of the state and take office in order to control the levers of state power. Now, here we are saying that a nation could be defined as a community feeling among people who feel they are distinct from other communities. What do we want to say here? That a nation could be defined as community feeling. This is true because nations formation always belongs to the community feelings, community emotions, and uh, communities what is demanding. So a nation has a powerful mixture of all these. So community feeling among people who feel they are distinct from other communities and wish to control their affairs. What they want, that we are here different from another communities, and we also want to control their affairs accordingly, because all of the community has a good feeling and they all has a good control on their affairs. This distinction could be based on common religion. What is here? This distinction could be based on common religion, language, acts. Because we are saying that there is a distinction. What type of distinction there? The common religion and language, and many other distinction we can say. When the entire population shares this feeling, we have what is called nation state. However, this is not the case with all the states, and that is why state and nation may not coincide. For example, the Kurdish peoples spread across Iran, Syria, Iraq, and Turkey consider themselves to be a nation. This is also very good here. That what the Kurdish peoples think about, as they are spread many acres, Iran, Syria, Iraq, and Turkey, but they are considered the Kurdish peoples. So they are also they have the state and nation. They can say also. Now we are coming to the point that what is family law, because we have covered here the state, family law. This is all we have to cover. So this is all according to the that what is family. As we are aware that family, what is family? This family is this in which we live, our father, mother, relatives, kids, and all sisters. This is covered. This is all about family. And if we say what is family law, this is here an area of law dealing with family and domestic issues like marriage, civil unions, domestic partnerships, domestic violence and abuse, adoption, surrogacy, legitimacy, termination of family relationship, divorce, annulment, property settlements, alimony, child support, custody, visitation right. So this is family law, because law is not like that. Law is that when we covered the marriage, what we have to think about, that we are considering about family law. First of all, we have to consider that, first of all, that is marriage. Second is civil unions. Third is domestic partnerships. And domestic violence also be covered in family law. Abuse is also, adoption also, surrogacy also, termination of family relationship also, in which all of these, child support, visitation rights, property settlements, these all of the term, all of the, we can say, issues are to be covered in family law. Dissolution of marriage. In Washington, divorce is called dissolution of marriage. The governing law is RCW 26-9. Washington is a no fault divorce state. This means you don't have to show anything more than irreconcilable differences. Now we are here that in Washington, we are going here that in Washington, divorce is called dissolution of marriage. They doesn't want to give their name. They want that this solution of marriage. The governing law is also there, RCW 26-9. And there is also covered here that Washington is a no fault divorce state. This means you don't have to show anything more than irreconcilable differences. Ending the marriage. File dissolution petition with the court, wait 90 days, get a final dissolution decree, three ways. Both parties agree to it, both argue in front of the judge, who enters a judgment, default decree entered. No one argues. Here, the ending of the marriage is called here. Because of and dissolution decree. What is dissolution decree here? Decree here, because of this is the end of the marriage. File dissolution. There is starting of file dissolution processes. Petition with the court, where they have to wait 90 days, and they got a final dissolution decree, that is in three ways. Both parties agree on that type of dissolution and decree, and both argue in front of judge. And what the judgment is declared, nobody argues on that, and a default decree entered. Now, dissolution decree. What is dissolution decree? Ends the marriage, decides the following matters. Because of, if a dissolution decree is to be passed, declared, then what will happen again? Ends the marriage. 1 point. Decides the following matters: marital property and debt allocation. Because there can be also in a family that is both parties want the dissolution decree. They have the marital property also, and they have the debt allocation also, custody rights also, child support also, spousal maintenance also, and restraining orders. Because divorce and dissolution is not a word, is not a, we can say, only one step. After that, many steps has to be covered, because all of the steps that is related to marital property, custody rights, child support, spousal maintenance, all of these has to be covered according to the judgment that is to be declared. What is marital property? Here, marital property is property of the marriage. Often it includes real property, houses and land, personal property, boats, cars, art, financial assets, cash, stocks, bonds, future interest, pension, retirement funds, contractual rights. There is a question arise here: who does this belongs to when the marriage ends? There is a question that who does this belongs to when the marriage ends? Answer is there: it depends. Because marital property have many branches. real property is there, financial property is there, financial assets is there, personal property is there, contractual right is there, and future interest is there. So all of these to be belong to, and if a marriage ends, what is to be said here, that is marital property. And marital property have the all of the uh, issues related to this, that what will happen if the marriage ends. And there is a question arises here that who does the belong to when the marriage ends. Then answer comes here, it depends. Community property. Most of the assets are community property. Each spouse is regarded as contributing to the well-being of the community and equally shares in financial well-being of the marriage. Each spouse has a one and a half interest in any property acquired by the marital community. 9. Community property states: Washington, California, Texas, Louisiana, New Mexico, Wisconsin, Idaho, Arizona, Nevada, Alaska, and you can choose community property. Here, there is a question also have community property. What is community property? Most money coming into the marriage is community property. This includes salaries and compensation, windfalls, sale of community property, interest and rent income. So this is community property. Most money coming into the marriage is community property. What is community property? There is salaries and compensation, windfalls, sale of community property, interest and rent income. Marital. Community, wife's salary, husband's salary, wife's labor, husband's labor. All of these to be counted as community property. Community and spread separate property. What is community and separate property? In we are discussing here family law. Strong presumption that property acquired during marriage is community property. Now here, what is community and separate property? You have to see here that strong presumption that property acquired during marriage is community property. Because if we say that during marriage we have got this property, that is to be called community property. However, some property is separate property. This is property that belongs to a spouse individually. Yes, separate property can be here because of this is the property that belongs to a spouse individually. Separate property. Property held by a person before the marriage. Property received as a gift or inheritance by a person. Rent and profits from separate property remain separate property. Here, what is separate property? If a person have the property before marriage, and second is a person received as a gift or inheritance by a person, that type of property, and rent and profits from separate property remain separate property. What type of rents and profits from separate property? This is also called the separate property. Now here, mixed property. Of course, property will get mixed together and this becomes mixed property. For example, a person may buy a house, then get married, and make payments after the marriage using income from their salary, which is now community property. Usually, a court will proportion this property, basically divide it up according to whether the money used to pay for it was community or separate. What is here? What is mixed property? Yes, of course, we can think, we have to see here that that type property will get mixed together and this become mixed property. What type of property have become mixed property? A person may buy a house, they get married, and the make payments after the marriage using income from their salary. So this type of property has become the mixed property, because he has taken the loan, and he has going after that he has got married, and he make payments from their salary after marriage, which is not what is happening here. That is now which is counted as a community property. Usually a court will proportion this property. Now the case has happened, and the court will decide the proportion of that property, how much the both of the parties will pay the property. Basically divide it up according to whether the money used to pay for it was community or separate. Because money, how much they have used, it is counted is in, as it will be counted in community or in separate way. Mixed property can cause funny things to happen. For example, a husband is injured in car accident and wins an award of $2,000, 1,000 for lost wages and 1,000 for pain and suffering. The 1,000 lost wages is community property, and 1,000 for pain and suffering is the separate property for the husband. Property and dissolution. What is coming here? That when the marriage ends, each spouse gets separate property, 1.5 community property. However, judges have discretion and can equitably distribute property, giving one spouse more or less than half community property. For example, if one spouse never worked and gambled away all the money, the court may award that spouse less than half community property. When the marriage ends, each spouse gets separate property, 1.5 community property. However, judges have discretion and can equitably distribute property, giving one spouse more or less than half community property. As because of the spouse never worked and gambled away all the money, the court may award that spouse less than half community property, because he has not earned that money, he has gambled away that property. So this is community property, and he is not giving accordingly that he has to be demanded. He is giving accordingly to what he has done. Community property and unmarried couples. Community property and unmarried couples here. In Washington, we allow for committed intimate relationship. Relationship must be stable and marital-like. Code will look at duration of relationship, cohabitation, pooling of resources, intent of parties, purpose of the relationship. Code will use equitable powers to distribute property based on community property principles. What is happening here? The community property and unmarried couples. What will happen here in that cases? We allow for committed intimate relationship. Relationship must be stable and marital-like. What is here? That stable and marital-like relationship should be welcomed. Court will look at duration of relationship. How much duration they have this type of relationship. Cohabitation. What is this cohabitation? That how much they have become habitual to each other. Pooling of resources. What is pooling of resources? How much they are happily pooling their resources for the betterment of their relationship. Intent of parties. what is the intention of their parties, the both parties. The relationship has a good intention, otherwise they have some greed related to community property. So there should be some intention should be cleared. Purpose of the relationship, what they want to be after this relationship. They want stable and marital like relationship. Otherwise, they what they want. Code will use equitable powers to distribute property based on community property principles. Now, court has the only way that they use the equitable power to distribute equitable powers to distribute property based on community property principles. There is also a answer here, also a principle they will count here, that is based on community property principles. Unmarried couples. What will happen here? Unmarried couples. However, Washington does not recognize common law marriages. Unmarried couple living together like a married couple, same as committed intimate relationship. So when disturbing property, distributing property at the end of the relationship, the code will use of the community property principles. But parties do not get any other marital rights like rights to retirement funds, pension, or health care. This is to promote public policy of encouraging people to marry. Because in the case of only unmarried couples, what will happen, what the court will decide, what the property should be, how the property should be divided. And community property, what will happen about the community property, and what they will get the marital rights, that is depend on after the marriage in Washington. Like rights to retirement funds, they will not get pension, they will not get, or healthcare, they will not get because they have not got the marital rights. And this is to promote public policy of encouraging people to marry. If they will marry, they will get all these marital rights. Custody. In any proceeding between parents. Now happening, now we have to count here, coming here. If what will happen in family law, what type of state has the power for the custody of the children? There is a custody. In any proceeding between parents, the best interest of the child shall be standard by which the court determines and allocate the parties. Parental responsibilities. This means that a court will consider the best interest of the child in deciding custody rights. There is also issues create what will happen if the relationship breaks here. What will happen? The custody of the children's custody of the child. So there is always remaining issues relating to that what will happen. They are declaring here there, in any proceeding between parents, the best interest of the child shall be standard by which the court determines and allocates the parties. Parental responsibilities. This means that a court will consider the best interest of the child in deciding custody rights. Custody rights has the many powerful image for the custody of the children. What are the best interests? The best interest also means maintaining the existing interaction between parent and child as much as possible. Best interest also means maintaining the existing interaction between parent and child as much as possible. The court decided to, and court have a good manner, court have a good intention about this, that what is type of best interest is also that maintaining the existing interaction between parent and child as much as possible. The parent child relationship is altered only because for a good society the parent child relationship should be counted, and it will be altered only to extent necessitated by the changed relationship of the parents, or to protect the child from physical, mental, or emotional harm. Now, here, parent and child relationship should be good interaction, but it change only due to if the relationship the parents are not in a good manner, because they have to protect the child from the physically, mental, or emotional harm. That is RCW 269 2002. Who are parents? Only legal parents have custody rights. Legal parents, who are legal parents here? Legal parents are natural parents and adoptive parents here. There are two only. They have the custody rights, adoptive parents and natural parents. Essential requirements of marriage. What is there should be the essential requirement of marriage? Both parties must have the ability to understand the nature of the marriage contract and the responsibilities and duties involved in marriage. What they want here, that essential requirements of marriage. Here, both parties, they have the ability to understand the nature of marriage. They have to understand the nature of marriage contract and the responsibilities, because marriage is not just a joy. Marriage is a responsibility and duties they have to cover, they have to handle. So first of all, both parties should be aware all of the understanding that this marriage contract is a responsibility, that responsibilities will come and duties will come, so they have to welcome all these. A person cannot marry if he is not mentally capable due to illness, alcohol, or drugs. There is also that if a person is not capable to handle the marriage responsibilities, marriage contract responsibilities and duties that will come with the marriage, if he is not capable due to illness, due to alcohol, or due to drugs. So if the society doesn't want to give the permission that he has to make the marriage to somebody. Valid consent. There is valid consent. What should be counted as a valid consent? Consent cannot be given under duress. There is example we have given here, that Hirani versus Hirani, 1982, fourth floor, 2232, CAA, Hindu woman living with her parents, went through a marriage arranged by her parents. But the marriage was never consummated, and she left her husband after 6 weeks. W sought a decree of nullity on the grounds of her parents' duress, but initially failed because there was no evidence of any threat to her life, limb, or liberty. The Court of Appeal granted the decree. W's parents had threatened to throw her out of the house if she refused to marry the man they had chosen. And this threat, coupled with other pressure, was enough to destroy the reality of W's consent. There cannot be a mistake of the identity that person is going to marry. this is we are going to hear this is valid consent. Minimum age or parental consent. The minimum age for marriage with parental consent is 16 in all provinces except Quebec, 14 male and 12 females. 15 in the territories. The minimum age without parental consent varies. In Ontario is 18. Refer to page 445 for a full chart. Absence of prohibited relationship. Now there is minimum age or parental consent. Absence of a prohibited relationship cannot be too closely related to each other by blood. Cannot be too closely related to each other by blood. So absence of prohibited relationship here. As we have seen here, minimum age of parental consent, there is 16 on all provinces and 14 also for male, 12 also for females, and 18 is in Ontario. It is 18, a full chart. Termination of prior marriages. In Canada, a person can be legally married to only one spouse at a time, a practice called monogamy. Polygamy is illegal in Canada. However, in BC, there are communities that practice this as a religion related case. Being married to two spouses at a time is called bigamy, which is a criminal offense in Canada and punished by up to 5 years in prison. An annulment is granted when one of the essential requirements for marriage was missing at the time of the marriage took place. There is an annulment is granted also when one of the essential requirement for marriage was required and that time when the marriage took place that was missed. That is termination of prior marriages because of polygamy is illegal and a person can be legally married to only one spouse at a time. An annulment is granted when one of the essential requirement for a marriage was missing at the time of the marriage took place. Sexual capacity. Now here, traditionally the purpose of the marriage was to have children. So consummation is legally validating the marriage through sexual intercourse between a husband and a wife. The solemnization of the marriage wedding ceremony. A couple must have a marriage license. Must be witnessed at least two people 18 years of age or older. The ceremony must be conducted by someone who is authorized to do so. Officiant, priest, ministers, getting hitched in donut shop. The solemnization of the marriage wedding ceremony. Couple must have a marriage license and the ceremony must be conducted by someone who is authorized to do so, by the priest, by the officiant, by the minister. Now we are coming here. What will be considered as what is custody and access? When a couple whether separates or divorce and children are involved, decisions have to be made about custody and access. What what scene can we create when we can see what happens after if the couple separates and the children are also involved in that case? What type of custody should be considered there? Custody, which parents the children of the marriage will live with? There is also a scene created. Which parent the children of the marriage will live with if they want to? Access parental visitation rights. Sometimes the parents cannot agree upon custody and access issues, and the courts become involved. Yes, both male and female. The parents does not want the access, the parental visitation rights, and this doesn't want to agree upon the custody and access also. What will happen here? The court become involved in that cases. In determining custody and access, the court will always look at what is in the best interest of the child. As any and many cases of these type, the court has to determine better solution for that, for the children, for the child, for the interest of the child. That is that court always think about the best interest of the child. He gives decisions related to the interest of the child. Sole custody. The children live with one parent, and that. What will happen if the sole custody arises? The court has given the decision that sole custody will be given. The children live with one parent. Parent makes the major decisions involving the children. Kramer versus Kramer, court scene. Joint custody. A custody plan in which both parents have a shared responsibility for the children. Joint custody is awarded in about 25% of cover. If the parents cannot cooperate as parents, joint custody may not be in the child's best interest. Yes, if the parents cannot cooperate as parents, they doesn't want to cooperate as parents, joint custody is not a good decision for the child's best interest. Joint physical custody, the children spend an equal or nearly equal amount of time living with each parents, and both parents make the major decisions involving the children. Joint legal custody. Joint legal custody. The children live with one of the parents while the other parents has generous access rights. Both parents have an equal say. Is a major decision involving the children. This is still the more common form of joint custody. Here, joint legal custody. The children live with one of the parents while the other parents has generous access rights. Both parents have an equal say in major decisions involving the children. States. Based on 2004 data of the 31,800 custody decisions that year, custody was jointly granted to the husband and wife in almost half of the proceedings, continuing the upward trend of the last 2 decades. Cases where custody of dependents is awarded to the wife only have been decreasing from 76 in 1988 to 45% in 2004. Custody cases granted to the husband only represented 8.1 in 2004, compared with a high of 15 in 1886. One possible explanation from the more rapid gain of male lone parent families is growing share of joint custody arrangements following a union dissolution, and fewer mother being granted sole custody following in a divorce. There is a data that is happening, that what is happening here, that the joint custody here, female fewer mothers being granted sole custody following a divorce. When one parent has been granted custody of the children, what will happen? When one parent has been granted custody of the children, the other parent will almost always be granted some form of access. This access can range from being very flexible and regular in nature to occurring only at specified times to being supervised and very restricted. Here, that this access can range from being very flexible and regular in nature to occurring only at specific times to being supervised and very restricted. In theory, doing what is the best interest of the child makes sense. However, this is an extremely difficult decision to make in certain situations. The court will look at the number of the factors and trying to determine what is the best for the child. Top 10 custody mistakes. User almost loses custody of the children. Child support. Both parents, whether they are married or not, have a legal obligation to contribute to their children's need. Federal child support guidelines are built on the principle that both parents should share the same portion of their income with their child as they would if they had continued to live together. In other words, the child should not suffer economically from a separation of divorce. In joint custody situations, support payments may be altered if the paying parents care. This is all about that the appropriate level of child support is based upon two key factors. There we have given here all of the thing that child support, what type of child support is to be granted here, that both parents, where they are married or not, have a legal obligation to contribute to their children's needs. So now we will again repeat all of the topic here. So be with me with the starting of this. We will have a glimpse of that what we have covered in this topic. What is important factors we have to think about again. This is family law and estate. We are covering here again. As usual, because family law and state, we have covered all family. Law is also related with the, because family is related to law and law is related with the family, and state has a overview of control all of them. So this family law and state, defining the term state is not easy, as we have said that the general agreement on a definition. State is not a easy word. It must be first be noted that there are various forms of state which differ from one another in important ways. Here, the Greek city state is clearly different from the modern nation state, and contemporary liberal democratic state which exists in Britain and Western Europe is different from the fascist type of state of Hitler or Mussolini, as contemporary liberal democratic state has a difference from the state fascist type of state of Hitler or Mussolini. It is also different from the state which existed in the former USSR in Eastern Europe. An important part of the is the explanation of what is meant by these terms. And now we can say a nation could be defined as community feeling among people who feel they are distinct from other communities and wish to control their own affairs. This distinction could be based on common religion, language. When the entire population share this feeling, we have what is called nation state. However, which is not the case with all the states, and that is why the state and nation may not coincide. For example, the Kurdish people spread across Iran, Syria, Iraq, and Turkey, and they have considered themselves that they are one nation. And now we are covering here, starting here, what is family law? Area of law dealing with family and domestic issues, marriage, civil unions, domestic partnership, domestic violence, adoption, surrogacy, legitimacy, termination of family relationship, divorce, annulment, property settlement, alimony, child support, custody, and visitation rights. These all is related with the family law. Dissolution of marriage. In Washington, divorce is called dissolution marriage. The law is that is Washington is no fault diverse state. This means you don't have to show anything more than irreconcilable differences. Ending the marriage. What is there to be think about? Dissolution of marriage, file dissolution, petition with the court, wait for 90 days, get a final dissolution decree in three ways. Both parties agree to it, both argue in front of the judge, and who enters a judgment. Default decree entered. Dissolution decree. This is the default dissolution decree ends the marriage. Decides the following matters: marital property and debt allocation, custody rights, child support, spousal maintenance, and restraining orders. This is related with that what will happen if a dissolution is marriage happened, that all of these issues to be covered by the judgment. What is marital property here? Marital property is a property of the marriage. Often it includes real property, houses and lands. What is real property here? Houses and land. Personal property, boats, cars. Financial assets, cash, stocks, bonds. Future interest, pensions, retirement funds. Contractual rights. There is a question here, who does this belong to when the marriage ends? Question is here, answer is here that it depends on the judgment of the court. Community property. What is community property? Most of the assets are community property. Each spouse is regarded as contributing to the well-being of community and equally shares in financial well-being of the marriage. Each spouse has a half interest in any property acquired by the marital community. 9 community property states: Washington, California, Texas, Louisiana, New Mexico, Wisconsin, Idaho, Arizona, Nevada, Alaska can choose community property. Most money coming into the marriage is community property. This includes salaries and compensation, windfalls, sale of community property, interest and rent income. This is community property. Married community, wife's salary, husband's salary, wife's labor, husband's labor. Community and separate property. Strong presumption of that property acquired during marriage is community property. However, some property is separated property. This is property that belongs to a spouse individually. Separate property. Property held by a person before the marriage. Property received as a gift or inheritance by a person. Rent and profits from separate property remain separate property. Property will get mixed together and this become mixed property. What type of mixed property here? For example, a person may buy a house that can then get married and make payments after the marriage using income from the salary, which is now community property. Usually a court will proportion this property, basically divide it up according to whether the money used to pay for it was community or separate. Mixed property. Mixed property can cause funny things to happen. Here. Property and dissolution. When the marriage ends, each spouse gets separate property, half community property. However, judges have discretion and can equitably distribute property, giving one spouse more or less than half community property. For example, if one spouse never worked and gambled away all the money, the court may award that spouse less than half community property. Community property and unmarried couples. What will happen if the community property is there and unmarried couples is there? We allow for committed intimate relationship. Intimate relationship is more important here. Relationship must be stable and marital-like. Court will look at duration of relationship, cohabitation, pooling of resources, intent of parties, purpose of the relationship. Court will use equitable powers to distribute property based on community property principles. Unmarried couples. Treat? What will be treated in unmarried couple cases? However, Washington doesn't recognize common law marriages. Unmarried couple living together like a married couple, same as committed intimate relationship. So, when distributing property at the end of the relationship, the code will use the community property principle. But parties do not get any other marital rights because of they have not got married, like rights to retirement funds and rights to pension or health care. This is to promote public policy to encourage people to marry. Custody. In any proceeding between parents, the best interest of the child shall be with a standard by which the court determines and allocates the parties. Parental responsibilities. This means that the court will consider the best interest of the child in deciding custody rights. What are the best interests and who are the parents here? Only legal parents have custody right. Who is legal parents here? They are natural parents and adoptive parents also. What is the best interest? To extinct necessitated by the changed relationship of the parents or to protect the child from physical, mental or emotional harm. In all of the cases, it means that the child, the court wants the best interest also means in maintaining the existing interaction between parent and child as much as possible. Essential requirements of marriage. Parents, parties must have the ability to understand the nature of the marriage contract and the responsibilities and the duties involved in marriage. A person cannot marry if not mentally capable due to illness, alcohol, or drugs. In these cases, he cannot marry. Minimum age or parental consent. There is a very important thing we have to think about here. There is a parental consent is 16 in all provinces. There is Quebec 14 male and 12 female. 15 in territories. The minimum age without parental consent varies. In Ontario it is 18. Termination of prior marriages. Polygamy is legal and a person can be legally married to only one spouse at a time. Being married to two spouses at a time is called bigamy, which is a criminal offense. An annulment is granted when one of the essential requirements for a marriage was missing at the time of the marriage took place. Sexual capacity, the solemnization of the marriage, wedding ceremony. Couple must have a marriage license, must be witnessed by at least two people, 18 years older, who is authorized to do so on official priest ministers. Getting hitched in donut shops. So now we have to going for the end. That is custody and access. When a couple separates or divorce and children are involved, decisions have to be made about custody and access. What type of custody is required here? Sole custody. The children live with one parent and that parents make the major decisions involving the children. Kramer versus Kramer court scene. Joint custody, a custody plan in which both parents have shared responsibilities for the children. Joint custody is awarded is about 25% of couples if the parents cannot cooperate as parents. Joint custody may not be in the child's best interest. So today we are ending this session. This is all about for the today. Thank you very much. Now we are going to end. Namaskar. Jai Hind.